So let's talk a bit more about examiner impartiality. The fitness for duty evaluation guidelines and IACP guidelines, guidelines number 6 and 7, state that the examiner owes an ethical duty to both parties to be fair and impartial and to honor their respective legal rights and interests. Even here, I think we've limited the scope of obligations by referring to simply two parties, the employer and the examinee. There are others as well. Examiners should decline to accept a fitness for duty evaluation referral when personal, professional, legal, financial, or other interests or relationships could reasonably be expected to impair their objectivity. Again, if in your own analysis you determine that a pre-employment psychological evaluation precludes you from doing that, then you shouldn't do it. Or if you decided that in a particular case, a fitness for duty evaluation, and your judgment of that person prevented you from being able to do so, you should do so. One example has been, for me, a person that I found to be psychologically unqualified for another agency. Another psychologist for another agency, never Mike, of course, does that evaluation and finds him fit, or qualified rather. He's hired, engages in the very kind of behavior that I predicted was going to happen and why I found him to be unqualified, and now I'm called to do a fitness for duty evaluation. Absolutely not. I'm not touching it. I can't be objective. So I think we operate along the same criteria. We rely upon the same criteria. We may reach different judgments depending upon our analysis of it. A good case example is the case of Dinhoff versus City of Grand Rapids, Sixth Circuit case. And many of you know Glenn Peterson, who was very active in IACP, Police Psychological Services, for many years, a dear friend, a wonderful guy. And Glenn got into a very sticky wicket in this case. Dinhoff was one of two female police officer plaintiffs in this case. And Patricia Dinhoff was the particular plaintiff in this particular portion of the case. And in a pre-referral conference between the chief and Dr. Peterson, according to both Dr. Peterson's testimony as well as a letter that he wrote the chief, as well as the chief's testimony, confirmed that in that initial conference and in a subsequent communication prior to conducting the fitness for duty evaluation, and now I'm quoting from the court's Sixth Circuit's finding, Dr. Peterson employed language that at a minimum suggested his opinion had already been formed. For instance, he noted that in view of the tension between Dinhoff and the department, quote, "It is difficult to imagine how she could continue to work in this environment." Further, he indicated that it did not matter where the fault lay, opining that the relationship required a divorce like a, quote, "marriage gone bad," unquote. This language should have signaled to Chief Dolan, and indeed to any reasonable recipient, that Dr. Peterson was predisposed to finding Dinhoff unfit for duty. Indeed, after comments like this, it is hard to see any possibility that Dr. Peterson's examination would yield a result other than finding that Dinhoff should be separated from the police force. Instead, when Dolan was confronted with a psychologist who had already formed his opinion before examining the patient, he asked that doctor to proceed with the examination. Now, there's a concept under the law called the safe harbor, the honest belief rule, which provides a safe harbor for an employer who relies upon that information as a reasonable basis for a subsequent rescission of a property right or a property interest, like terminating the employee, firing the employee. In doing so, Chief Dolan forfeited the protection of the honest belief rule, because the jury could have easily concluded that his reliance on a doctor who had already made up his mind did not qualify as reasonable reliance. So be careful of your paper trail. If your paper trail includes anything that you think may reflect bias, just concede to it. Don't want to do it, irrespective of whether you think you actually have the bias. If it was perhaps intemperate of you to have said so, you didn't really mean it the way it was said, you know, you really were open to it, you were being a little flippant at the time, oh well, refer it to someone else. Decline the referral. If you know that you can't be objective or impartial, decline the referral. And be careful, of course, of what you say.